Welcome back to The Lawyer You Know, and today we're jumping back in the Lori Vallow Daybell case because a status conference happened today to determine whether or not she was still incompetent to stand trial. But before we get to that hearing, which we're going to play and react to on this video, make sure you subscribe to our page. We're on our way to 10K. When we get there, we're going to have a lot of cool things that we're going to do with the firm as a whole, all the lawyers. We might do more giveaways, which we are doing right now starting this Friday and every Friday in September from here on out because of our 1 year birthday. And it just so happens that they're so close together, the 1 year and the 10K, which is awesome and all testament to you guys, a part of this community that want to get together, talk about cases, talk about legal facts, talk about legal rights, and make sure everybody has a lawyer they know that they can ask questions to, and we can provide answers and guidance and help wherever you guys need it as a community. And we also learn so much from you as potential jurors in all the cases that we pick and we may potentially try. We love to hear what you think about cases, what you think about witnesses, what you think about evidence. So keep the comments coming, keep the chat coming. We love to hear from you guys and interact throughout the process. So without further ado, let's get into this status conference on Lori Vallow's case and Chad Daybell. Yes, I know her last name is technically Daybell as well, but to differentiate, we say Vallow and Daybell. There's actually a lot in this status conference about Chad Daybell's case. So stick through to the end to find out what's going on with that. Are we going to trial in 2 months or not? First part of the status is about Lori Vallow. Second part is about Chad Daybell. So stay through the whole thing and I'll give my comments about how this is all affected and explain some of the legalese they use throughout this hearing.
All right, good afternoon, everyone. We are on the record. I'm actually going to call both cases here. We've got some issues relating to these two companion cases. KCR 2221-1623, State versus Chad Guy Daybell, and KCR 2221-1624, State versus Lori Vallow, aka Lori and everyone Daybell. On the record. All right, appearing we've got Rachel Smith for the state, Rob Wood and Lindsay Blake also, Mark Means from Miss Vallow, and Jim Archibald. Also present is defendant Mr. Daybell and his attorney Mr. Pryor. We are recording this on the court's FTR system, as well as it's being reported by our court reporter, and it's also being live streamed on the YouTube channel of the Idaho Supreme Court for public access to this hearing.
So that's cool. And with the R. Kelly case, a lot of people are like, oh, federal courts, I wish it was filmed. I wish we could watch it. Well, the public access, the Idaho Supreme Court is allowing public access to hearings like this so we can watch it, so we can react to it, so we can talk about it and see and hear exactly what happens in this status conference.
So the first matter I want to call up today is in relation to the CR 2221-1624 case, State versus Lori Vallow. In that case, we had a hearing last week on August 30th relating to the commitment order that was issued by the court. We continued that to today, and I extended temporarily the commitment order, awaiting a progress report from Department of Health and Welfare relating to the current competency of or not competency of the defendant, Ms. Vallow. The court has since received a progress report dated September 1st and reviewed that. So let me just verify first, Mr. Means, have you had an opportunity to receive and review the progress report?
I have, Your Honor.
All right, and Mr. Archibald, have you seen that as well?
Yes.
All right, I'll ask a representative from the state then whoever wants to respond. Has the state also received the progress report?
We have, Your Honor.
Very well. The court's considered the progress report in this case. It's at this status conference, I think just a determination for the court to indicate whether or not the commitment order would be continued based on the progress report the court has received and the information from the Department of Health and Welfare. The court does find and determine at this time that pursuant to Idaho Code 18212, the defendant, Ms. Vallow, is still not competent to proceed with the proceedings in this case.
So there's our big answer. In the last video we did, the progress report was not up to the standards of the court or the lawyers. They sent the doctor back saying, we need a full report by September 8th. That has happened now. And the court is saying that based on that progress report, she is still not competent to stand trial. We're going to hear if any of the lawyers have a problem with that. And we're also going to hear how long is the court going to stay the case now? How long are we going to have to wait for another progress report and to see if Lori Vallow can be competent to stand trial? Let's listen to what the judge says.
This case will be stayed pursuant to statute for an additional 180 days. And during that time period, then if another progress report comes in indicating restoration to competency, then we'll schedule a hearing sooner. If not, then we will set another status conference at 180 days.
So we learned something there, okay? So it's 180 days. But what did he say? He said, if we get a progress report sooner that she is competent now, then we can schedule a hearing sooner than 180 days. So let's keep that in mind as we're following this case. If something comes out sooner and they do another status conference to see if she is competent to stand trial, that's a good indication that she will be competent at that point. On the other hand, if we wait the full 180 days, we don't hear anything, and another status conference comes just because the statutory timeline of 180 days and the doctor has to provide a progress report, I think now we're going to know that the indication is she's still incompetent to stand trial, not competent to stand trial. So let's just keep that in mind as we follow the case, because we can all learn exactly how this process goes in Idaho with what their statutes say.
To again review the progress of whether or not Ms. Vallow would be deemed competent to proceed with trial. So I'll be entering an order to that effect, which will effectively stay that case then for that additional 180-day time frame. So that will be the order on that. Any questions on that order, Mr. Means or Mr. Archibald?
No, Your Honor.
No, Your Honor.
All right, Mr. Wood, Ms. Smith, or Ms. Blake, any questions on the court's order regarding the 18-212 proceedings?
No.
So it doesn't seem like any of the lawyers on either side have an issue, no questions. Based on the progress report, which earlier in the hearing, they all said they saw the progress report, they had an opportunity to review it. Doesn't seem like there's really any major objections or issues because there's not a lot you can do as a lawyer. If a doctor says they're incompetent, they're incompetent. So there's really nothing that you can do to force competency to stand trial. So they didn't have a lot to say there. But now we hear a little bit about Chad Daybell's case, which is really interesting to me.
All right, thanks.
Sorry, there was one other thing I wanted to mention. So he said he's going to stay the case for 180 days. What does stay the case mean? Basically means nothing can happen. No discovery, no hearings, no motions, no testimony. Nothing really is going to happen in this case while it is stayed for 180 days. Now, the parties and the lawyers can agree to do some stuff, but you need to have your client there analyzing this discovery, answering questions, going through, like if the state provides pictures or if they provide text messages, you as a lawyer need to be able to talk to your client. Is this real? Did you send this? Do you have a copy of this? Did they cut out any text? Do you have your cell phone so we can compare? And if you don't have your client involved in that process because they're incompetent, usually not a lot can get done. So I wouldn't expect anything to get done in Lori Vallow's case over the next 180 days.
All right. Thanks, counsel. We'll get that order entered in the case then. There's a few other issues I wanted to bring up on the record then relating to Mr. Daybell's case, who again is here present with counsel. We have a trial in the case that's scheduled for November 8th, so 2 months from today. In the intervening time period, we've got some motions that would be heard. We've got a change of venue motion scheduled October 5th and 6th. There's also just been filed a motion for severance. And further, the grand jury transcripts are, as I understand it, almost completed, but not yet completed and submitted to counsel, which are necessary for review by the defense as well as the state in order to go forward. Those are not done. And so given all those circumstances, counsel, I know we've discussed this previously informally, but it would appear to me, one other important point I guess I'll bring up, there was a waiver of speedy trial filed by Mr. Daybell on August 20th. And so given all those considerations, it would appear to me that really it would be impractical to try to commence this case 2 months from today on November 8th. I understand there may also be some discovery issues that are not yet completed. So
Okay, so you, as a lawyer, you can just sink and hang your head because you know what's coming as he starts down this road. They've discussed it informally already, a continuance of this trial, which was supposed to happen 2 months from today, basically, November 8th. But the court said multiple motions have been filed. A hearing is set in October. We have discovery issues. The defense has waived speedy trial. A lot of people don't know. Speedy trial is not automatic. Every client doesn't just get a speedy trial. You have to actually invoke that, which puts time restraints on the state, and you have to be ready by a certain date. A lot of times it's actually worse for the defense to try to do a speedy trial because the state already has everything and the defense can't really catch up and get on the same page as the state, which is difficult. But there are some circumstances where it's worth it to make the state give you a speedy trial. But lots of times, most cases, 99% of cases, the defense waives speedy trial. The judge makes sure to put that on the record. And you can just hear as the judge goes down the line that a continuance is happening. We're not going to see this trial in November, so we can all just check or cross that off of our calendars. What was also interesting is the judge mentioned that the grand jury testimony had not been fully transcribed yet. Why is that important? Grand jury testimony is sworn under oath testimony that can be used as impeachment in the real trial. All the lawyers need to know what those witnesses said. They need to prepare, cross, and direct based on what those witnesses said. And they need to be prepared to impeach witnesses if their testimony changed from the grand jury testimony. So those transcripts are infinitely important, and the trial cannot happen without them. And they're not even done yet. So if all those transcripts aren't done yet, there's no way this trial is going on November 8th, especially with a big motion like change of venue. If they're going to change the venue, they need to kick this down the road a long time. So we're going to see if the judge has an idea of when this trial is going to be set as he continues to talk through the issues in this case.
The court really on its own motion feels like it's probably appropriate to continue this trial. And so that's where I think we're headed. But before I go ahead and make that final decision, I'll just ask first from the state, is there any objection to us vacating and rescheduling the trial in this case to allow for additional motion hearing?
So what's interesting, and you may not have caught it, is the judge said on the court's own motion, we're going to try to continue this trial, meaning the court itself, the judge is making a motion to continue trial, which is not common, but it does happen. But the judge is just saying there's no way. I know neither one of the lawyers want to file a motion to continue because neither one of them want to have the media jump and say, why did the state continue this case? Why did Chad Daybell's lawyer continue this case? And when the media comes after them, they're making all these assumptions and accusations and trying to figure out why the lawyers are doing this. So the judge just kind of takes one for the team and says, listen, we need to continue this case. It's on my motion. Do you guys have any objections? Let's hear what the lawyers say.
There is not an objection, Your Honor.
All right, Mr. Pryor, have you spoken to your client about the possible continuance of the trial in this case?
Judge, I've discussed with him and done my due diligence. There's no objection.
Okay, without any objection, then that's just the reality of where we are in this process. I know there's a large amount of discovery and other probably significant motions that need to be heard. So
it's interesting that Pryor says, I've done my due diligence. I've talked to my client. No objection. He's CYA the whole time throughout this case, as all the lawyers should, because everything's looked at through a fine-tooth comb here, and the microscope's on all of these lawyers here.
the court is going to vacate the trial currently scheduled for November 8th. What I'd like to do is get one more trial date scheduled that would be the date that will stick. In order to get a date that we know is going to work and we can stick with, I think it's going to be necessary for us to set a scheduling conference after the change of venue motion, because depending on if venue is changed or not, that could have an effect on our scheduling. So
they're not even going to try to set this trial date until next month in October, when they have the change of venue motion, which makes sense, because if they are going to change the venue, like the judge said, it's going to affect the entire time it's going to take to try this case. But it's going to be a while before we even know the new trial date in Chad Daybell's case. Maybe Lori Vallow will be competent by then. So that's another thing to just keep in mind as this can gets kicked down the road.
I will reach out to counsel and we'll set up a scheduling conference sometime after the October 5th and 6th change of venue hearing.
So they're not actually going to decide it at the change of venue hearing. He's going to try to schedule a scheduling conference with the lawyers, which is just that, a conference to schedule the trial, schedule when discovery closes, schedule when they have to let everybody know what their witness list is, what their exhibit list is, when they have no more hearings, or make sure all their hearings and motions are done by a certain time. There's a separate hearing just to schedule that. So it's not going to happen in October. It's going to happen after that hearing in October.
And we'll get the matter reset for trial after that motion's been determined. So that'll be the ruling on the current trial setting. Any questions on that, Mr. Pryor?
No questions, Your Honor.
Any questions from the state on that regarding the trial setting?
No, Your Honor.
No, Your Honor.
All right, thanks, counsel. So related to that then, Mr. Pryor, you filed a renewed motion to extend time under 12B for motions to be filed and heard. The state filed a response basically indicating no objection if the trial were to be moved. Since the trial's been moved then, I think the motion is well-founded and without objection from the state, then the court will grant your motion to extend time for 12B6 motions to be filed and heard in the case. The deadline on that will not be scheduled until we get our trial setting, and then we'll look at setting a time frame on the 12B6 cutoff once trial is scheduled. So I'll enter an order granting your motion to extend time on that.
Thank you, Your Honor.
So again, just another motion to extend the timelines out, which obviously if the trial was not going to be moved, maybe the judge would not have extended those timelines out. But because just to have a fair trial, he had to, the judge granted that, no real objection or fight from the state. If we're going to kick the trial down the road, then we might as well extend discovery and allow more motions and things to happen in the process.
All right, I think that pretty much covers all we needed to go through on the hearings for today on the record. Is that correct, counsel? Was there anything else we discussed that we need to bring up, Mr. Wood?
I don't believe so, Your Honor. I think that's it.
All right, Mr. Means or Mr. Pryor, Mr. Archibald, anything else from the defense on the record today?
I don't think so, Your Honor.
I don't believe so, Judge.
Okay, thanks, counsel. We'll go ahead and go off the record then at this time. And
All right, so a lot happened there, right? Lori Vallow extended her incompetency another 180 days. Chad Daybell's trial was continued. We're still going to wait and see what happens on October 5th and 6th if he gets a change of venue. So we're going to keep an eye on this case. We're going to keep following it. As always, let me know your questions. What do you want to know about this conference? What do you want to know about this hearing? What do you want to know about this case? Let me know in the comments and let me know what you think. Do you think it's a good thing or a bad thing for Chad Daybell that they've continued his trial? Are you surprised Lori Vallow is still incompetent to stand trial? Let me know, because that's what we're here for. We want to get into your minds and hear what you see and think as a layperson who may be a juror in a case like this one day. Let us know, because we love to hear your input. We love the diversity of thought. Feel free to share whatever thoughts and questions you have. But that's all we have for this video, and we'll catch you next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.